Good day to you and welcome to another Paddocks Club video tutorial. Today I want to talk to you about a number of terms used in dispute resolution procedures and place these in the context of the Sectional Title Schemes Management Act and the Community Scheme Ombuds Service Act, which we expect to come into operation later this year. As you know, under Prescribed Management Rule 71, under the Sectional Titles Act, sectional title disputes must be resolved by way of arbitration. And similarly, in many homeowners associations, either the MOI or the Constitution provides for the resolution of disputes by way of arbitration. Now, arbitration is a formal proceeding in which an impartial third party makes a judgment about fault and lays down decisions. They're called awards, which are legally binding on the parties. Arbitrators are normally experts in the field of the dispute, and they have fewer constraints on the way in which the evidence is presented and decisions are made than the courts do. Arbitration is a private process, so there's no general body of arbitration awards that people can refer to and sort of extrapolate a potential result from their own circumstances. But arbitration isn't the only way sectional title or other forms of community scheme disputes are resolved. Many go to court. In community scheme litigation, you primarily are dealing with attorneys, lawyers who look after their own clients, and trial lawyers, specialist trial lawyers called advocates. Some court cases are reported and made available as part of South Africa's case law, and there they serve as guidance to the public generally. The Community Scheme Ombuds Service deals with conciliation and adjudication. Conciliation has traditionally meant a neutral third party who helps people to get to the table, whereas mediation, by contrast, has meant a third party who does a little bit more than that. They actually assist the people to make the decision, decide the terms, they manage the process. We expect that the type of conciliation which the Ombuds Service will offer under the Community Scheme Ombuds Service Act will be a combination of these processes. Conciliators will be people who understand community schemes sufficiently to guide disputing parties as to what is possible in that particular type of scheme, what levels of consensus are required, what filings or survey or registration may be required to effect an agreed solution, but to allow the parties to make their own decisions. If, however, the parties are unable to solve their problems at the conciliation level, the matter will be escalated to adjudication, which will be closer to the traditional arbitration, but better controlled. Again, the Ombuds employees, part or full-time, who are the adjudicators, will be people who know about that particular type of community scheme, and in this case, they will actually make the decision as well as applying the relevant law and circumstances. All the adjudication awards will be published by the Chief Ombudsman so that the public generally can see the likely results of the processes they're involved in by looking at past adjudications with similar circumstances. Thank you for joining me, and if you have any questions, let's deal with them in the discussion forum.